Appeal number 31, Kolchins versus Evolution Markets. Counsel?
It pleases the court. My name is David Wexler with the law firm of Wexler & Cohen on behalf of the appellant. It is truly a privilege and a pleasure to appear before you. There are two distinct...
Counsel, do you care to reserve any rebuttal time?
Yes, I should have said that. I'd like to reserve 2 minutes, please.
Certainly.
There are two distinct issues before the panel today. One is whether or not the motion to dismiss, which was denied with respect to an alleged production bonus under an existing agreement, should have been dismissed, and the other has to do with the formation or the lack of a formation of a contract. I'll go with what I think is the narrow issue to begin with, which is the production bonus. And basically, as I said, that is entirely distinct. It arises under a 2009 employment agreement. That employment agreement...
In this case, what's the movement's burden?
The movement's burden?
What did the movement have to show?
The movement's burden has to show that, number one, first of all, there's documentary evidence. There's a 2009 agreement here, and whether the agreement is clear, unambiguous, and there's plain meaning on its face, and consistent with the law, which is the Pachter and Truelove case, all right, whether or not the agreement unambiguously states, as the parties are allowed to state, that there are conditions to receiving a bonus. In this case, there are two conditions. I should say one condition.
But
yes.
There are certain provisions under the labor law that would counteract that, and based on public policy, right? And one of them has to do with whether it was a discretionary bonus. And can we tell that as a matter of law based on the documents here?
You can.
How can we tell that?
Well, first of all, you don't have to find whether it was discretionary or not, in the sense that since the agreement says one must be actively employed in order to be eligible, and we'll get back to your point.
No, but you're putting the tail before
No, I'm not, Your Honor. I'll tell you why. Because the Pachter and Truelove cases say that the parties are free to go away from the common law. All right, so they are allowed to determine whether or not you have to be actively employed in order to be eligible. And if you
But what they're not, what the employer is not free to do is to not pay someone for the work that they've done. That's the nub of the question.
Well, that goes to whether or not, under the labor law, which goes to Judge Stein's question, it was an earned bonus. All right, and the law is no. And why is it discretionary? If you look at the actual contract clause, the contract clause says, on the terms set forth below, you are eligible to be paid a bonus on a trimester basis based on your performance. Get back to that in a moment. Any such bonus will be paid within 2 months of the close of a given trimester. The total bonus pool available to the desk will be no less than 55% of the earnings of the desk. The labor law says that if there is a direct linkage between your performance and what you're getting paid.
Well, he was in charge of that desk, right?
He was in charge of the desk.
And didn't you just read the words based on your performance right out of the agreement?
No, Your Honor. All right, because there's a bonus pool. And if you look at the law, there's no formula for Mr. Kolchins to get paid directly. There's just a pool. The employer gets to determine how much of that pool he gets. But there's a pool for everybody on the desk. And if you look at Mr. Kolchins' own brief, all right, on page 31, I believe, of his own brief, he admits that the contract language specifies how the bonus was to be earned, no less than 55% of the net earnings of Mr. Kolchins' trading desk. So there's a desk that earns a pool. The employer then decides how to allocate that pool. Mr. Kolchins has no formula. He has no minimum guarantee. He has no fixed sum. It's purely discretionary coming from a pool, and there's never any money allocated to Mr. Kolchins under this.
Isn't this, though, from our point of view, really a question of what standard of review that we're going to be applying? Isn't it really a question of 3211 standard of review, the burden's on you? You've got a situation where one side says, I points to the email, it says, I accept, please send me the contract. The response is Mazel Tov, I look forward to working together. The other side says, we didn't complete this contract, there was no consideration, we hadn't finished it, the 5 elements haven't been met here. that's a perfectly legitimate summary judgment argument, but it's not a 3211 argument.
It is a 3211 argument
Okay, you
because
tell me why.
when you start out with the general notion that, yes, allegations in a complaint have to be deemed true for purposes of a motion to dismiss, and that reasonable inferences have to be given to the plaintiff. You then go over to the second, and that is where there's documentary evidence that refutes an allegation or inference, then the documentary evidence will supersede. So the question now, and it's a matter of law before the court, and was before the lower court, is whether or not the documentary evidence refutes. Now, this is a unique case because the parties all agree that you have all the documentary evidence. There's no dispute that it's complete. The parties all agree that it's accurate that's before you. There's never been an allegation that anything before you is not complete or not accurate. There's never been an allegation by the plaintiff that there was something additional or oral.
The issue is whether the question can be decided on that documentary evidence or whether there is additional evidence that needs to be brought to the fore before it can be decided.
And I would submit to you, it can be decided. It's a matter of law. If you look at the Spear case,
Well, it
which
seems
is
to me that there's a perfectly reasonable view of this record
Yes.
based on I may mess up the dates here, but the June 12th and the July 16th emails, that there was an offer and there was an acceptance. And then what happens after that, and the offer sets forth the terms pretty clearly. And after that, there's a whole lot of discussion and the whole thing dissolves. But if at that point there was a contract, then what happened after that is superfluous.
It's not
But-
superfluous.
Well, if there was a contract at that point, it was. But now there's maybe another view of the evidence that says, no, wait a minute, there's a custom and practice here, there's some other things going on, and in fact, there was no meeting of the minds at that point. But getting back to Judge Fahey, why is that not a summary judgment question rather than a 3211 question?
Well, if you look at the Spear case, which admittedly is the First Department, not the Court of Appeals, it says that this is a matter of the law. Interpretation of documents is a matter of the law before the court. It's not a matter of fact.
But that doesn't mean that every view of documents will give you the answer to the question that you're looking to answer.
Agreed, but what I was about to say before is there's no allegation here that there's been any oral statements or oral promises in addition to what's before the record.
Well, you don't have to, you've got the documents. Mr. Kolchin has one narrative, you've got a counter-narrative, and that's the point. That can't be enough on a 3211.
But it is under 3211 if the documents refute the allegations. That's why you have a 3211
You're saying
documentary.
if there's only one way to read the documents. Isn't that what you're saying?
Well, I'm saying under the law, if the documents refute the allegations.
Utterly refute, conclusively.
It does say utterly
There
refute.
can't be another reasonable interpretation in order for you to win on a 3211 motion.
And I believe, all right, Justice Friedman laid this out in a 19-page dissent, that there's no way to read these documents. The majority looked at 3 documents. There were 20 emails. There were 3 draft agreements. There was a letter. And if you look at the case law says that when there are ongoing negotiations, when there are drafts, when the parties have historical context of having entered into a written agreement in 2005, a written agreement in 2006.
Well, but the historical context is also that Mr. Kolchins performed before those agreements were finalized, no?
No.
That's
No.
not? Is that a
On one of
disputed
the
fact?
agreements, which was the 2006 agreement, which although it goes into effect on September 1, he signed it in December. I think that's what you're referring to. But the agreement before that had no term. He was an employee at will. It was only the 2006 one where he had his first 3-year term.
So for the first one, they performed without a written contract, and the second one, he performed before the contract was signed.
No, if I was obtuse, I apologize. The first one was a written contract which just was terminable by either party on 30 days' notice.
And he began performing before it was signed or after?
No. He began performing pursuant to that contract. The 2006 agreement, which wasn't signed until December and was retroactive until September, that was signed after, but he was still operating under the written agreement, the 2005 agreement.
Because, counsel, I'm sorry to clarify, because that 2005 agreement had no definite termination date?
It just had either party could terminate on 30 days' notice. Unlike the other contracts, which were 3-year contracts, subject to automatic renewal and subject to termination for cause and things like that.
Thank you.
Thank you, counsel.
Time goes fast.
You'll have your rebuttal. Counsel.
Good afternoon. May it please the court. Joe Hammond at Debevoise and Plimpton for Mr. Kolchins. I'll turn first to the extension agreement, if I could. And I think the linchpin of our position here is obviously that email exchange that concluded on July 16th, 2012, that's at pages 112 through 113 of the record. And I think the things I'd like to emphasize about that email exchange are its clarity, it's crystal clear, it's unambiguous, it's comprehensive, and it's quite formal, actually. The subject line in the email is "in writing," and drawing all inferences in the favor of Mr. Kolchins, as you must at this procedural stage. What does that mean? It means that what was intended was that this would have the formality of a writing. It was something that could be depended on. And it was something that would make the offer clear and capable of acceptance. You then have a recitation of the material terms, but it goes beyond that. You then also have this statement that if there are any issues unaddressed by my email, refer to the existing contract that we're extending. So you really have every single issue covered in that email, in a crystal clear email that appellant was at pains to say was in writing.
And what's the impact of the issues that were negotiated after?
Well, I think Your Honor's questions about the procedural posture here are very apt. It's undeniable that the attempt to memorialize this agreement in a more formal instrument broke down. But there are multiple inferences that can be drawn from that fact. There are different arguments about why that happened, and there are different arguments about what it means that that happened. We contend that all that shows is that at some point along the way, Evo Markets decided to renege on the agreement, and they therefore injected new terms that were different from what had already been agreed on July 16th. And what the Supreme Court said and the First Department said, which was correct, is that you can't choose between these warring inferences here on a motion to dismiss.
Counsel, your view of the facts is that on July 13th, before that email sent, there's some kind of meeting. And it's at that meeting where they essentially agree to these terms?
No, Your Honor. It is alleged in the complaint. There was a meeting on July 13th. That's where Mr. Kolchins asked to have the offer in writing so that it would be crystal clear, so that he could see it in writing and respond to it in writing. And that confirmed that the offer had already been put in the email. He wanted to confirm that it was still there. They discussed it, and then he accepted it on July 16th.
And what specifically is that offer in writing? What email is that?
So that's the one that is on page 113 of the record, and reading up goes to 112. The offer that was made in June by Mr. Ertel, who is the CEO of the company. And Mr. Kolchins then discusses that offer on July 13th. There were other discussions as well, but there was a meeting on July 13th. And after the meeting on July 13th, he accepts the offer.
So what does it mean in this email that we're talking about from, July 15th at 11:49 a.m., where it says at the end, of course, you do have your existing contract, but before that says that this is the contract other than a clarification around the issue of departed members. How is there a meeting of the mind if there's a significant issue that they haven't agreed to?
Well, I wouldn't call that a significant issue. I think the law, the Cobble Hill case of this court, says you don't need to have every single issue ironed out. Certainly, all material terms have been agreed, the compensation, the term of the agreement, the dispute resolution, the restrictive covenants, all of that is covered by this email exchange. They're saying there's going to be one issue that needs to be...
Well, what you say, it's the
checked.
existing agreement, right?
Yes,
Isn't
by
that what
which...
this email says?
By
It's
which he means the
existing agreement?
2009 to 2012
all-
agreement.
Meaning all terms hold, except we've got this one little thing we've got to clarify?
Exactly right. And that's how I read the email. I think we're entitled to that inference, certainly at this stage. And I believe that's what was discussed at the July 13th meeting that Judge Garcia asked about as well. So you really do have all material terms covered.
Ultimately, the question is whether the parties intended to be bound before a signed writing, or we're going to wait for a signed writing, right?
That's right. And what the Stonehill case says, this court's precedent in Stonehill, as well as the First Department case in Cowalchuck, says what you need if you don't want to be bound by a writing like this is some express reservation of intent not to be bound. And what you don't have anywhere in the record of this case is anybody saying, we're not bound. That's just not there at all. And that's why there are...
Please send contract isn't good enough.
Police and contract is absolutely not good enough. To contend that that is an express reservation of intent not to be bound, especially at the motion to dismiss stage, I would argue is untenable. And especially in light of this court's precedent in Stonehill, where you talked about the phrase...
Stonehill was such a different case, wasn't it? As I remember Stonehill, it was a bid, right? It was some kind of...
It was a bid, yes.
This is very different than a bid. Bid, I accept. And then they were working out different terms related to payment and other issues. This is an exchange of different emails and different conditions, and then it's, I accept, please send contract, but if you read that in light of all the other things, it seems there are conditions that haven't come out, and they're waiting for a formal writing to resolve those.
They are waiting for a formal instrument. There's no question about that. But there's lots of cases that say just because you anticipate a more formal instrument doesn't mean you don't have a meeting of the minds. And I would argue, Your Honor, that this email exchange is not at all confusing, actually. The 112 to 113 record email exchange is crystal clear. It's comprehensive. It's formal. They chose to label it in writing for a reason.
So
And what we're arguing about
if they
here...
label it in writing, then why is he using the word contract? Doesn't that suggest that perhaps he's only viewing this as some negotiation of what will be the final terms?
I think that's a perfectly fair argument for the defendant to make to the fact finder at trial. What does that mean?
Does the fact that there's a merger clause make any difference?
Well, there would be a merger clause if they had reached the point of memorializing this, but there's no merger clause that's applicable here.
Well, except that there was one in the prior contract, and you're saying the terms are carried over into the contract you have now.
Right, so it's intended.
So there is a merger clause.
Well, I guess if you look at it that way, then there's a merger clause that says anything prior to July 16th is superseded. So we're stuck with where we are on July 16th. And that's fine. I think that means that we have an agreement on all material terms.
Counsel, move for a moment to the production bonus.
Sure. Two quick comments I would make on the production bonus. Again, I think the questions from the court about the procedural posture are very apt. This is only a motion to dismiss. The other point I would like to make
What about the absence of any amount or formula or anything in the contract for how that bonus would be determined?
Well, there isn't an absence. There is, that it's 55% of net revenues, and then a specific...
The pool, but how much of that pool do you get?
Right. What is missing from this record that will be developed, actually has already been, we're in this strange posture where we're talking about the motion to dismiss after discovery, there is ample evidence in the record of how this bonus pool was treated and calculated, and it absolutely was not discretionary. It absolutely was treated as guaranteed. I was surprised to hear my adversary say that that production bonus is discretionary. If you look at the language of the contract, it doesn't have the word discretion in it anywhere. It doesn't say that management will decide how much of this pool you get.
But it says you're eligible.
Says you will be eligible.
You will definitely get. You will receive. It says you are eligible.
And contrast that with these parties know how to use the word discretion when that's what they mean. There's also a discretionary management override where it actually talks about discretion. There's also Mr. Kolchins' prior contracts where what is now the production bonus, effectively, functionally, used to be called the discretionary bonus. And it used to say this is a bonus that you will get at our sole discretion. And then, as he got more senior, that language got changed, and the word discretion got taken out, and it no longer says anything about discretion. So to call it a discretionary bonus, I think, is at best another argument of fact that could be made to the fact finder at trial, but it certainly is inconsistent with the language of the actual agreement and the use of words elsewhere in the agreement and in the parties' history of prior agreements. If your honors have no further questions, I'll rest on my brief.
Thank you, sir.
Thank you.
Counsel?
Judge Rivera, you brought up the fact about the departing members, and I think that's not one little thing. When a departing member leaves, whether or not that departing member's discretionary bonus stays in the pool, doesn't stay in the pool, goes to the firm, or goes back into the pool is significant.
Well,
And that was-
but isn't that in itself, a subject of other evidence? We don't know. He says it's not significant at all. You say it's significant. Again, isn't that inappropriate for us to decide on a 30 to 11
It's not,
motion?
respectfully. The test here, all right, under Zhang, under Brown Brothers, is totality of the circumstances. And Judge Garcia, you touched upon this a little bit when you said, in light of all the other things, all right? And I believe what happened here was the First Department paid lip service to the totality of circumstances test, but then focused on 3 emails, what Judge Friedman calls 3 sketchy emails, and ignored 17 emails, and ignored, and I think this is critical, 7 different requests, and you didn't hear this from my adversary, 7 different requests by Mr. Kolchins to change the agreement, seeking to increase his non-compete payment to more than what was in the prior agreement, whether other employees' bonuses would limit Kolchins' eligibility for management override, whether bonuses for commissions received by Evil Markets in the second trimester would be counted against his guarantee. These are all by him. Who at Evil Markets could approve management overrides, whether Kolchins would serve on the management committee, to whom Kolchins needed to disclose potential employment opportunities, and the effect of the clawback of the bonus. Those are 7
And
material
those are all
items.
after the July 16th email where he says, "I accept"?
Yes, and if you look at Gleesi, and if you look at Spear, and if you look at, I think it's Yeoman, they all say that you take into account everything that occurred. Prior history, you take into account future, you take into account future negotiations, you take into account drafts of agreements, and you look at the whole picture. You don't look at a little isolated portion, which is what the First Department here did and what Justice Friedman had a problem with. The last thing I'll say is on the production bonus, there was a question as to whether it's discretionary. By definition, it's discretionary because there's no methodology on how much he's going to be paid, so by definition it is. The last thing I'll say to you is in footnote 2 of the decision, the court says that mazel means congratulations. I will correct the court. It means good luck. So to the panel, mazel to you the rest of the year.
Thank you, counsel.